Good evening, wherever you are listening to us. This is Splash 105.5 FM, your integrity station. Welcome to Insight for this week. I'm your anchor, Oluwaseun Akinola. Well, the CAMA 2020 is picking up our attention today, and we want to look at it from the perspective of the law, vis-a-vis the reactions that had greeted the passage of that law. Amid cheers from the Nigerian business community over some friendly provisions of the act, which was signed by President Muhammadu Buhari barely 3 weeks ago, an endless uproar had been billowing from the Christian community, some part of the civil society organizations, over some provisions of the CAMA 2020 Act, which these groups had considered obnoxious. Chapter 4 of the Act, titled Suspension of Trustees, Appointment of Interim Managers, etc., houses the contentious provisions under Section 839, subsections 1, 2, and 3, which empower the Corporate Affairs Commission, CAC, to wield what anyone could call the big stick of the defaulting organization by suspending its board of trustees and appointing interim managers. Now, before I bring in my guest, I'd like to read Section 839, subsection 1, which provides that the Commission may by order suspend the trustees of an association and appoint an interim manager or managers to manage the affairs of an association where it reasonably believes that A, there is or has been any misconduct or mismanagement in the administration of this association. B, it is necessary and desirable for the purpose of 1, protecting the purpose of the association, securing a proper application for the property of the association towards achieving the objects of the association, the purposes of the association of that property or of the property coming to the association. 3, public interest, or C, the affairs of the association are being run fraudulently. Section 8392 further provides that, and I quote, the trustees shall be suspended by an order of the court upon the petition of the commission or members consisting 1/5 of the association, and the petitioners shall present all reasonable evidence or such evidence as requested by the court in respect of the petition. Now, subsection 3 provides that upon the hearing of the petition and the appointment of the interim manager, the court, with the assistance of the commission, may make provision with respect to the functions to be performed by the interim manager or managers appointed by the order. Now, the groups that have decried these provisions of the Act argue that it could be misapplied to their advantage, and the question should be, how will this happen? I have Dr. Olu Ojedokun in the studio. He's a barrister and solicitor in Nigeria, and is of the Faculty of Law, Leeds City University. Dr. Ojedokun, welcome to the program.
And of course, top of the day to you.
How are you today?
Yes, I'm fine, thank you.
It's good to have you here.
Thank you.
Great. So, I've read the provisions of this law that has been contentious, and of the face value, if you look at it very critically, before we pull the context, is it something that is obnoxious, like many people have said?
Let's get the proper context, as you've suggested. The Act comprises of a total of about 870 sections. Spread over 604 pages, compared to the previous Act, which the sections were limited to about 600 and thereof. And there are only a few sections actually that actually deal with non-for-profit organizations, not specifically churches, not specifically mosques, but non-for-profit organizations. And those sections are dependent on the number of ifs. In fact, if you look at the contentious section 839, subsection 1 and thereabout, there are about 10 what I would describe as conditioned precedents before taking over, you understand, the suspension of the trustees, the appointment of interim managers. So there's quite a lot of hurdles to be crossed. So it's not just automatic. And
before you get to that
before
point.
You get there, it has to be 20%. The law says 1/5. 1/5 is 20%. So 20% of the trustees.
So let's get it clear. What you're saying, because I saw it in that section 2,
Yes.
that's subsection 2 of that says that it needs the buy-in of members of the trustees.
Absolutely.
20% of members of the trustees.
Absolutely.
So maybe they were thinking that these members could go rogue on the entire bunch.
Even if they went rogue, there are a number of conditions. Fraud is one of it.
Must be established.
Yes. Going outside the object of the charity or the non-for-profit organization, maladministration, they're quite specified, And even after I specified petition, the evidence has to be presented to the court, you understand? So it's not just the Registrar General, you understand, on his own, in collaboration with some 20%. There's still a process to be followed, there's evidence to be tendered, and of course it has to be examined by the courts before a decision is made.
So the Registrar General cannot sit in his office, collude with some people in the trustee and the board, and then suspend the trustees.
It's going to be very difficult.
He will need the court.
Yes, ultimately he's going to need the court to sanction that, you understand? So the petition, remember that a petition is presented, you understand, coming from the office of the Registrar General, making sure there's got the 20% of the trustees, making sure that the evidence is attached, making sure that all those ifs, so 10 of them, actually subsections, are attached and presented to the courts. And it's only when the court, of course, is satisfied, you understand, then the suspension takes effect. Of course, after the suspension, then the court, working with the Registrar General, of course, then has to appoint an interim manager. And there's certain requirements, conditions, or specifications that the interim manager may be given. So it's not a straightforward process, and it's not that easy to accomplish, from that point of view. And it's not specified that it should just be churches or that it should just be mosques. It's basically non-for-profit from that point of view. And we have to understand the philosophy of non-for-profit.
Okay.
In any sense, you don't have to be registered if you're a church. You don't have to be registered if you're a mosque.
Really?
Yes, you don't have to be. But if you are, you understand, then you're regulated. And regulated by the CAC through this law, from that point of view. You could even apply for deregulation. You understand? If you want just one. But the disadvantage of that is that if I have St. Olu Church, you understand, for the sake of argument, it's not registered, nothing happens. If anything happens to St. Olu Church, they will come for me. They will come for my assets. They will come for everything that I own. You understand? But if it's registered, you understand, and things happen, they can't come for me personally, you understand, because I'm a body corporate. I become corporate in that sense, a personality in my own right. So that's why a lot of people will register. But if you feel that the regulations of the government are onerous, if you feel that they are, there's some gimmickry going on, then you're free not to register or deregister, as the case might be. That option is always open to NGOs or churches or mosques or whoever is concerned. You would also note that the churches, the established churches, the Church of Nigeria, Anglican Communion, the Catholic Church, even the Baptist Convention, you would notice that airy silence, from that. They're not really protesting in that sense.
Why? Why do you think they're not?
Well, because they're established. They're very well established. They don't have few trustees. They've been there over the years, and so of course have a lot of systems in place. The constitution is well established. From that point of view, and you don't have like a single person really in charge. The influence of a single person there is limited by the structures, by the laws governing, or the constitution rather governing this organization. So it's more difficult, as it were. From that point of view, for people to feel that they are in control. The smaller churches or some of the Pentecostal churches, one or two people are really in control. They are the visionaries. They are in charge. And therefore, what you do is when these rules or these laws come into place, there's a slight opportunity or slight hint that control might be wrestled from them, from the vision which is in their hands might be wrestled from them.
So that points us to probably why some of them were really, vicious about this law. Now, these contentions, these arguments about the law, is it rightly placed or rightly situated?
Now, I can understand why sometimes they would have a grievance. The grievance, obviously, is that if, for instance, you're a church, and I focus on church because a lot of the complaints are coming from church, and there's a spiritual mandate, and there's a vision that the Lord has given you and granted to you. And no matter what the infractions are, people would argue that it's between them and God ultimately. And then to introduce someone who possibly may not even be a Christian, understand the ethos and the values of that church, on an interim basis to come and run the church, you understand, may not be able to, you understand, run it, you understand, because he doesn't understand the vision and it's not part and parcel of the vision carriers. And so I can understand it from that point of view. But a lot of times, if you look at the United Kingdom, when these interim managers are brought in, they don't get involved in the spiritual dimension of it. They don't get involved in the preaching.
They don't get to go preaching in the church.
No.
They don't get to take charge of the spiritual programs.
No, but what they do take part of is the management of the assets, the commercial aspects, the commercial ventures. Because really, all these churches, all these NGOs, they cannot be taxed on income that is charitable. But the moment they venture into business, into making profits,
many of them do.
Yes, they're subject to tax, for that, but for the charitable activities, they're not subject to tax, you understand? And of course, there are about 4 heads, you understand, the education, religion, relief of poverty, and so on and so forth. And there's a more general omnibus section. So really, my concern is that we may be encouraging, in some respect, bad governance in the non-charity, non-NGOs.
In what way?
Well, if you're saying that NGOs don't want to be regulated, if you're saying that NGOs that are charities don't want to be answerable to government regulators, then where is the self-regulation? It means that they're just onto themselves, by themselves, and there's lack of regulation. And I don't even think that the scripture, you understand, supports, you understand, laissez-faire, no regulation. There has to be accountability, And ultimately, some would argue that the accountability is to God Almighty. Yes, it's to God Almighty, but when we go to church, even though we know that our accountability is to God Almighty, we still have people over us, overseers, and people that we can account to, from that point of view, and people we can confess to one another. So I think, you understand, that the churches may have had a legitimate grievance if they said that the CAC does not have the competence or the expertise, and let them set up a different specialist body like a charity commission that operates in the United States, in the United Kingdom and other countries. They would be on more solid ground in that respect. But the kind of, some might say, knee-jerk reaction where you just dump, you want the old law just dumped wholesale like that, it's not going to happen. And I don't think it's a constructive way forward, from that point of view.
I'm going to take you on that specialized body that you feel could handle, the charity organizations. But I was reading something that the Vice President said at the virtual conference of the NBA recently. He said, and I quote him, "We have a process by which this CAMA law can be redressed. Whatever the proposal for amendment may be, whatever the view of the leadership of the church may be, regarding the question of how the trustees, whether they are interim trustees or not, can be put into a proposal that will be brought to the National Assembly for consideration for an amendment to the law. This is a process which is entirely opened and ought to be pursued." He further said, "We're in a democracy and there is a process by which things can be done, and that process is the one where you bring forward amendments to the National Assembly and they will do whatever is considered useful in the circumstance."
But why does the church or why do the NGOs have to wait for the law to be enacted before they consider it to be inept or inapt or not
satanic.
appropriate or satanic? What were they doing?
Describe it as satanic.
Yeah, well, and
so you're saying, what were they doing?
Yes, because the process of making law, you understand, is sometimes like cooking. There are about 3 stages, you understand. First, you have the first reading. Then you have the second reading. In the second reading, you have the public committees where everybody gets involved. And then you have the third reading. And even after the third reading, there are some technical committees that harmonize, you understand, some of the suggestions, some of the amendments, and so on and so forth. And then, of course, it's presented at that stage to the president. So, in between those steps, what were the churches doing? What were the NGOs doing if they are complaining at all? So that's the problem. But having said that, of course, I align myself with the position of the erudite professor of law, the vice president, that amendments can be pursued, amendments can be tabled. And I think if churches are uncomfortable with the law as it is, then of course they should pursue those amendments, from that point of view. And because the sections we're talking about, because I said there are about 870 sections. And if you look at 839, you understand, and you take it down, you see that there are only really a few sections that deal with NGOs. So it's not going to be a Herculean task
for the assembly.
Yes, to amend those sections. Or better still, as I said, you pursue the setting up of a specialist body, because the church industry in Nigeria, and I dare say the mosque industry, if there's such an industry, you understand, is quite enormous. You understand? Because what they've done is they've lumped churches together.
To use the word industry suggests a little bit.
Well, suggested. Well, I use the industry because they employ. I use the industry because they make a lot of money. I use the industry because a lot of taxes also comes from their commercial activities, and I'm using it in that sense. But a lot of people will not be happy with me from that point of view. But let's just say the NGO industry is quite enormous. And for the CAC to be lumbered with it, in my view, you understand, is you're expecting too much from the CAC.
What do you suggest?
Oh, that they should set up a separate commission, you understand, that deals with non-for-profit. From that point of view, non-profit organizations, they can then scrutinize, they can look, and then because they understand the terrain, when it comes to appointments of interim managers or trustees, you understand, it's going to be easier for them and they're going to better be able to handle it. Some people would argue and say, okay, what if churches that are into commercial activity, would they be able to handle it? The way that you resolve that is that some churches or some organizations can register both. You can register under the CAC and you can register under the charitable or charity commission from that point of view for your non-profit activities. It could be done. It's been done in Britain and there's no reason why it cannot be done here.
Some have suggested that many of the churches here are subjected to such law in the UK, for instance, because they have their branches there.
Yes.
And so why are they against such a provision here in Nigeria?
Well, I think that's a kind of saying, you understand. I don't necessarily agree with it, that when you're in Rome, you behave like the Romans. And so, of course, when you're in Britain, of course, that's the law of the land. You abide by the law of the land. It is because they are law-abiding. That's why they abide by the law of the land here. And if there's a law here which also applies, then they should abide by it. I think, that in many respects, the foundations of those churches are not in Britain, they're here. You understand? And so they feel that those international outreaches, you understand, whilst they may be subject, they're not the core of their ministry or they're not the core of their mission. So I think they are able to live with that. But I think their grouse is that where the church is formed, where the people are in charge, you understand, they shouldn't be subject to such onerous or such similar rules. They would say that many of the countries are irreligious, particularly United Kingdom, so they wouldn't really understand them, and that's why they bring about those laws. But in a country which is supposed to be spiritual and religious, they ought to understand that you touch not thy anointed, you do thy prophets no harm. You understand? Which in my view sometimes is a misquotation, you understand, from the scriptures.
We'll take a look at that some other time. But let's look at this section 8 through 9 closely. It provides that the commission may be made by order, suspend the trustees of an association and appoint an interim manager or managers to manage the affairs of the association where it reasonably believes that and it listed them.
Yes.
Let's look at it. What is in this provision that might be making the churches not to be happy?
Before we go there, it uses the word reasonably believes.
So who determines?
The court will determine reasonably believes. But it's very interesting. I put the word reason. It could have put the word believes. It has to be reasonably. It's not beyond any reasonable doubt. But of course, the onus is on the Registrar General. The onus is on the commission to prove, you understand, that the belief is grounded in reason. And if it's not, then there's no way forward. So having established that there's reason to believe, then you then go to those sections A, B, and so on and so forth. It goes on. It says this or has been any misconduct or mismanagement in the administration of the association, it is necessary or desirable for the purpose of. So it goes again and say it is necessary. It doesn't just stop there. If you had stopped there, then you say, well, if there's any mismanagement, or then there's a problem. But it says it is necessary or desirable for the purpose of protecting the property. Is listed securing a proper application of the property of the association towards achieving the objectives of the association, the purposes of the association of that property or of the property coming to the association. It mentions public interest. It goes on to say in C, the affairs of the association are being run fraudulently. But that would be after, you started, you understand, from reasonable belief, and then it qualifies. So there are a number of if, subsections, cul-de-sacs, in and out. So it's not that easy. Then it says the affairs are being run fraudulently, the trustee, and this is reasonably believes.
So there must be some level of establishment of fraud.
Yes,
and then mismanagement.
Yes.
Now, I want to before you go to the second part of that 839, is there a sense of arbitrariness in the provision of this law, this particular section? Is it arbitrary?
Yeah, when you say reasonably believe, I could reasonably believe that all people of Babalawos, you understand, are all crooks. I could reasonably believe. And I could reasonably believe because all the Babalawos have come across, you understand, for whatever reason. I've had unpleasant encounters with it. So it could be reasonable. So, of course, you could argue that arbitrariness, because that's my reasonable belief as the Registrar General, if I were, from that point of view. So that argument could be made that there's a degree of arbitrariness. But thank God, you understand, that it alone doesn't take that decision. It needs 20%, you understand, or 1/5 of the trustees, and of course it needs the court. So there's still that hurdle which hobbles, you understand, whether the Registrar General is, you understand, from just acting arbitrarily, even if he wanted to.
All right, so the church can somehow hold on to factor. So if we're going to amend this section, what do you think should be considered to be amended here?
Well, if they're going to amend the section from that point of view, I would want to a certain extent that the threshold of 20% be increased.
Jacked up.
Yes, and maybe say 50%. That would be my view anyway. That rather than say 20%, there may be 50%, because then 50% it means that you've lost confidence in the trustee. But 20%, you could get rabble-rousers, you could get troublemakers, you understand, who just precisely, you just want to filibuster or whatever, and just truncate progress in the church. So that would be my view if there was going to be any, you understand, amendment to this process. But the rest of it, to me, I think is in order, and I think works well. In any case, this is, I'm sure, will be tested by some churches if it ever happens. It will be tested by some churches, and then it is only when these things have happened that trustees shall be suspended by an order of court.
So the commission must have established all the provisions of 839 subsection 1 and all the ifs there.
And the petition, you understand, must be presented, you understand. And that petition, of course, will be signed by the commission, you understand, and members, 1/5 of the association, which is basically trustees. And it's presented, you understand. So not the commission alone, they have to work together, you understand, with this 20% or 1/5, whichever one we use, in order to get this through, to the courts, from that point of view. And they will look at it. Registrar General, do you have the threshold? Have you met the threshold? What's your reasonable belief based upon? Where is the documents? Where is the evidence? So it's going to go through a process. And this is not a one-day wonder. The way the courts operate in Nigeria. It's not going to be a one-day wonder at all. So there's time, you understand, from that point of view.
So those who argue that the CAC will probably be taken up over churches are probably not speaking the truth to the document.
They're probably being inaccurate. They probably haven't read it in its totality, and they're probably just what came out at them is suspension. Usually what happens, in many of the churches, not all the churches, but some of the churches, is that the pastors and the trustees, you understand, most of the time are one and the same, and the pastors and trustees are actually quite powerful. You understand? It is my vision. It is my church. Were you there when God spoke to me? And so when somebody, an errant trustee, you understand, who's supposed to be subject to the authority, you understand, subject to the authority as in the Mosaic order, you understand, and not being an Aaron. And when somebody is doing that, you say, this guy is apostate, you understand, he's really going against it. And now he's gone with the unbelievers, you understand, to come and interfere in the vision that God has given. So that's the kind of approach that is taken. But I would take the other approach, that churches should be models of good governance by true self-regulation, so that when people point to churches or point to them, they can use them as examples and say these churches are well run. There is absolutely no question at all. And I think if it's well run, it will be very difficult to get the 20%. I've said I suggest 50%, but it's going to be very difficult to get 20% or so.
Let alone 50%.
Yes, and there are other thresholds apart from that anyway, from that point of view. But I think that's the affair, that in a lot of these churches you require unanimity to a certain extent.
The program is insights on Splash 105.5 FM, your integrity station, and we're looking at the issue around CAMA 2020. And I have a barrister and solicitor of the Supreme Court of Nigeria and the Faculty of Law, Leicester University, Dr. Olu Ojedokun, right here with me. Dr. Ojedokun, thank you for being here.
It's my pleasure, of course.
Great. So, we're looking at this act and checking the provisions and the reaction of people. You said that churches, for example, should be models of good governance.
Yes.
There is at the heart of these provisions of the act the sense of good governance, corporate governance,
yes,
and accountability.
Yes. And transparency, of course.
And transparency.
Yes.
Now, so who should hold the church accountable if it is registered under government?
Well, my view normally is that if the CAN, Christian Association of Nigeria, was working the way it should, then they ultimately should be able to hold churches accountable. But the way churches operate, they operate freestyle, and they only choose to obey or choose to go with what CAN says. It's consensus, isn't it? And they operate by consensus. But in this stage, since CAN is not, you understand, able to regulate, of course you have the CAC regulating it from that point of view. And that's why I've argued earlier that what we need is a charity commission, you understand, with every charity commission having a specialist department. So you have the churches department, you understand, dealing only with churches. You can then have the Muslim department or Islamic department, and then you can have Babalawos are registering Babalawo department or any other charitable course. And that's what happens normally when you have a charity commission from that point of view. They will be better able to regulate, understand the terrain, and there will be more confidence, because for a law to operate fully, it has to have the confidence of the people that it serves. And I fear that for many of the charitable organizations, which indeed are owned by churches, you understand, and are planted by churches, there's a lot of lack of confidence. Whether they're right or wrong is not the issue. If a law does not command the confidence of the people that is expected to regulate or serve, then we have a problem. And I think that's part of the issue. I'm not suggesting that churches don't obey it, but I'm suggesting that they need to have confidence in the process that is supposed to regulate them.
Now, the law says once you submit yourself by accepting to register with the CAC, you are bound to obey all its laws as well. Now, how is it that a registered member who qualifies to be a trustee in an organization will not want government to know how the organization is run?
Well, again, that's part of our misunderstanding of the role of government.
Yes.
You know, we are expected to obey all those in authority and like. So I think churches for a while, you know, not just churches, but many churches, and not all churches, but a lot of churches. You have to understand the way churches came about. You know, many of these new Pentecostal movement, many of them receive a word from God, you understand, I'm not doubting it, and then they set up the structures, and before you know it, you understand, the church actually grows larger than the structures. So many of the churches, the number of people are larger than the structure. So the structures are not necessary. The foundation in terms of structure is not really robust enough from that point of view. And it's this lack of robustness that has allowed them to express some doubt as to outsiders coming in. This is always a good thing for people from outside to assess you and to give you a bill of health. Some of them may be mischievous, you understand, but still it's always good, because then it allows you to do some introspection. Yes, some self-correction, and to say, you know, and I think for too long, many of our churches, not all our churches, some of our churches rather, I withdraw many, you understand, have basically been onto themselves, not having aligned external bodies, external bodies like the Christian Association of Nigeria, the PFN, to be able to have an insight. You know, peer review. We have one church pastor, you know, goes to the other church maybe for one Sunday or 2 Sundays, you understand, and the other comes, and then they compare notes. All those things will help the church in terms of the way they run it, in the terms of the way they administer it, and in terms of, you know, self-regulation, which they will be able to commend to anybody.
I love the idea of self-regulation. I'm concerned about this fact. Somehow, it is usually not open to the public or even to the members in their entirety. The income, the expenditure, how it is done. Maybe in some churches you have this documentation done every maybe quarterly or annually, but shouldn't church show this example, like you talk about model for good governance, for transparency, for corporate governance, to show how they expend the income and properties of the organization, how they appoint members of the governing board, how the properties are managed, even for their members, organizations, whether the NGOs, even some NGOs are in this basket,
yes,
where they do not put all of these things on the table for people to see. So it seems, is it that we don't want to be regulated really, or we want to be transparent?
I don't know. I happen, you understand, this is a coincidence. I happen to be the Chapel Council Secretary of the Chapel of Peace and Joy, Leeds City University, and we had a meeting yesterday with the accountant, with the auditor, where report was presented, where our accounts were audited, and everything is transparent, from that point of view. I don't know whether I should be saying this at this stage, but of course, we are accountable to the university management, and it's going to go to the university management. And I feel all churches, you understand, should have audited accounts, should be transparent. If you look at the Baptist Convention, you understand, because I'm not a member, but I know what they do.
So they should have audited accounts?
Yes. At the Baptist Convention, these are usually presented, you understand, to the membership. There's usually a meeting where it's presented. And there's some churches that have what you call the laity, where they have a meeting of lay members, you understand. I've forgotten what they call it in the church, in the Anglican church.
Okay, different churches. Some churches call it annual general membership meetings.
Yes.
The
CCC, what's it called? I can't remember. I'll remember in a minute. But a lot of these churches have the meet maybe weekly or parish council. The parish council, that's what they call it, where members can scrutinize assessments, scrutinize donations and building works and everything. So it's not just left to the pastor or left to the minister. And for instance, we know in the Baptist Convention that if the church members vote that they don't want the minister, then that's the end of it from that point of view. But it's not the same all over, and we have to realize that the church of Nigeria is quite broad and quite wide, from that point of view. Maybe this law, you understand, in an unwelcome way, is going to allow churches to look inwards themselves, force them to look inwards and ask the key questions, critical questions. What is it we've been doing wrong? What is it that we've left out by omission rather than a commission? Because I believe most of them is by omission, not commission.
So let's look at the issue of transparency for churches now. You have alluded to the fact that they should have this kind of meetings. What would you recommend, to enhance transparency in the operation of NGOs, CSOs, churches, mosques, who fall under this law?
Well, the CAC already, anyway, it will require them to have their annual general meetings, you understand, of the charitable organization, of the NGO. They will require to submit accounts, and they will require to have audited accounts. They will require to have a company secretary, all those sort of things, you understand, if they are registered, you understand, under the CAC. Before, there used to be an option, incorporated trustees or company limited by guarantee. Unfortunately for that, company limited by guarantee is only the Attorney General of the Federation that could grant permission. And of course, that was quite onerous. So it's now less onerous. So all the structures are provided for, you understand, under CAC that you have to subscribe to. But if you operate as a very small charity, as a one-man sort of operations, some of those requirements might be quite onerous. And that's why if you look at it, you understand that the CAC has gone as far. Some people may say it doesn't apply to not-for-profit, but I don't agree entirely. It's gone so far to say you can have a situation where you just have one director, you understand, and not necessarily having a company secretary, depending on the size, of course, of the concern that we're talking about. But we're more particularly concerned with not-for-profit from that point of view. I think if a church concentrates on its mission and its vision, you understand, then there should be no concern as to the CAC at all. You understand? But it's when churches stray into other activities like business and so on and so forth, and then that's where the issue arises. And that's where, of course, issue of whether there should be fraud and so on and so forth. And in any case, if there's fraud in a church, shouldn't it be in the church? You understand that those people should be exposed and to be dealt with before it becomes such of a concern, from that point of view. For you to get 20% of trustees rising up, going in arms and linking up with the Registrar General, it must be something pretty serious that may have occurred.
And so the church or the mosques or the CSO or NGOs must understand from that perspective that there is that level of probity.
Yes. I think the basis of regulation for non-profit organizations is that when a person or group of persons apply to register a charitable organization, where we call it non-for-profit, the implications are that this is an undertaking, a venture which will benefit the whole of society. Therefore, government would confer upon it some privileges, and such as exemption from taxes and so on and so forth. In consideration whatsoever, the funds that come into it for the public, they come into it for the public, they are not for personal use. I think there's a trade-off here. Government is saying that, okay, for being a charity, for providing education, for providing religious services and so on and so forth, we will not tax you. But because you are registered for those purposes, we will require some regulation, you understand, some accountability, some transparency from that point of view. And because churches haven't done this in the past, that when change comes, I don't think change is always welcomed wholesale initially. But I think with time, many of the churches will see that the hue and the cry, it's not as so much as anticipated or as predicted by many people. I would have suggested that pastors, ministers, overseers read this law, or get lawyers, you understand, within their congregation to read the law and interpret what the implications are for them. Is there anything they're doing that is against the law, that lacks transparency or accountability? Then if there is, then I think in line with the scriptures, in line with the Bible, you understand, they would have to rectify it.
Now, some people have said that this section of this law is a reenactment of the non-governmental organization regulatory bill or commission that was muted some time ago.
Yes.
Do you agree?
Well, in some respect, yes. There's some aspects of it that were transferred into this law. But a lot of it is cut and paste. I'm sorry to use that expression. Cut and paste from Charity Commission in the United Kingdom. It's really similar if you look at it from that point of view.
Really?
Yes. Well, because, the Charity Commission is specialist. CAC is not specialist, and that's the argument that I have. You understand? That whilst the law in itself is not perfect, whilst the law in itself is welcome, what they should have done is set up a different body. But it's a different bureaucracy, and some people would argue that you're setting up a new bureaucracy, isn't that going to consume some finance and so on and so forth? But, well, what we want at the end of the day is good governance, we want accountability, and we want this NGO sector, which is poorly regulated at the moment, you understand? Because we're not restricting it to churches, NGO generally, you understand? And they need to be regulated, so that people get their value for money, and when people contribute, they can contribute with confidence that the money is going towards the object that has been suggested. Object means if you say that you're going to provide education, then you shouldn't be found doing something else, like providing hotels. That's not what you're supposed to do, from that point of view.
No, I asked you areas we can amend. You already said that we can move to 20% to 50%.
Yes.
Now, this area of appointing interim managers, wouldn't it be something that is going to cause some kind of problems if, for instance, you now bring someone who is probably not of the same faith to now be in the board of a faith that it doesn't belong or share the values?
Double-edged sword, because some might argue that if you bring someone who's outside the structure, who is of the same faith, that he may have some grounds that he wants to set. But I think you make a valid point that in the interim managers, if there's an aspect of the law which emphasizes their competence, alignment with the beliefs, you understand, of the charity that they're being assigned, you understand, to administer. So, for instance, if the issue has to do with Church of Babalawo, that's an oxymoron. You understand? Babalawo organization, you understand? Then whoever is appointed the interim manager, of course, should have knowledge of that, should be an adherent of in some sort of way. So I would agree with that, from that point of view. If you are dealing with the Catholic Church, if you are dealing with Muslims, I think it would be wrong if you are dealing with a mosque and you went to bring a Pentecostal Christian or Christian of any complexion to come and be the interim manager. I don't think it will work at all. Whoever is the interim manager has to still inspire some level of confidence, some level of competence, from the people that he's seeking to run. Or else what will happen is that the charity will just more or less disintegrate, because people won't attend, people would not come there, and there will just be fracas all over the place.
So now, National Assembly, when you advise National Assembly, for instance, on this matter, if they have to amend this law, what will be your advice? We have had two things now that I've highlighted. Do you have more or any other thing that you're looking at?
No, well, I think three. First is that they have to look at the interim managers. If they are appointed, they must have competence and they must have understanding probably be an adherent of the faith. Yes, that's it. But I also think that a separate charitable commission or charity commission be set up, and the threshold should be increased from 20% to 50%. I think if we have those three things, it would inspire better confidence in the charitable sector, particularly within the churches from that point of view. But also, yes, the onus is on the other side. The onus is on the government. The onus is on the commission. The onus is on those 20 members. But there must also be a period of time to which these interim managers can act.
It's not stated.
It's not stated, and I think that's a problem here. So there must be a period of time, 6 months. Or something like that, so that they know it's for a limited period of time, and within that 6 months, they can ensure that order is restored, transparency is enthroned, and accountability is established.
Now, many people have been looking at the church, but I'm looking at the NGOs. Yes. A particular lawyer, I don't want to mention name now, recently told me that this law also stifles free speech, free expression, and association.
Well, I'm not sure. There's a provision which has to do with merger, when it's suggested that after a period of time, that the churches or the NGOs are not true to their objects or true to their values, that the Registrar General has the power to merge, you understand, various organizations so that at least they're working in the interest of their vision and so on and so forth. But I'm not sure that it does. The reason why I'm not sure that it does is that the threshold, you understand, for registration to a certain extent has been lowered. And what do I say? Previously, before, you have to have at least 2 people. Now you can even have 1 person before you can register, from that point of view. So I would say that if you look at it as the whole, the CAC as the whole, I know it's not necessarily NGOs. I think the objective of the new law, CAMA 2020, was ease of doing business, was to bring more foreign direct investment. And if it's ease of doing business, and if these charities are not about doing business, if they are about charitable works, then let's hype them up and let's get a charitable commission responsible for dealing with them.
I've actually seen a lot of discussion, and that also aligned with this thought that these companies and Allied Matters Act, but CSOs are not companies, NGOs are not companies,
they're not.
Churches and mosques are not companies.
They're not, but the problem.
But they involve in business ventures.
That is it. The way it is that they're not companies, you understand? They're not businesses, so-called.
Orientation.
Yes, in orientation. But what then happens is that Monday to Friday, many of these people have to maintain their ministry, maintain their building, pay workers, and of course they sell books, they sell materials, some of them going to concerts, and there are many other things that they do, you understand? So whilst at the core of it, they're not businesses, they're still being run as businesses, you understand, from that point of view. So it goes beyond the Sunday service, it goes beyond the Jumat service, it goes beyond the Bible study. There are many other activities going on from that point. But if you look at it, if you look at the resources of the Catholic Church worldwide, they're possibly into billions, if not trillions, from that point, the Catholic Church worldwide, from that point of view. And if you look at the churches, really, they have a lot of assets, they have a lot of resources from that point of view. So the point is that, do you allow those resources to be outside government regulation, or do you allow it to be within? Particularly if people are asking for protection from taxes, for protection to have corporate personality, do you just allow them to do whatever you want? If I come to you and I say, Mr. Sheung, please, could I just have a use of your car? You understand? Of course, you might put certain conditions for me using your car, from that point of view. And if I balk at it, then I should be prepared not to use your car from that point of view. And it's the same thing when government, you understand, registers you. There's certain requirements, there's certain obligations, and if you're not interested in following them, the option for you not to register or to deregister remains available.
So, your final statement about this law?
Well, I think the law is an innovation. I think it's an improvement. I think they got some things wrong, but not many things. I think what they try to do with this law, try to do too many things at once. I think the law should have, the CAC should have been split up. You have the CAC and then you have the charitable or charity commission from that point of view. I also think for my profession, you understand, yes, you don't need company secretaries now in some of these small organizations.
Yes, sort of merits there.
I'm not sure it's the wisest thing, but people will say that people will say that it eases doing business. That
why would you say that?
Well, you always need a lawyer to advise you on when you're going wrong. You understand, when you're not doing things appropriately. Well, of course I am. But on a serious note, you understand, there are many small organizations that if they need a lawyer, if they need legal advice, they know where to go. And putting a standing company secretary there, you understand, may be onerous for many of them.
Some people are going to court because of this law.
Well, they're going to court, and I wish them all the best as they go to court, because all these things are supposed to be tested. And I think, yes, let them test it. And if there are areas that are deficient, I'm sure the court will pronounce on it, and we have better laws as a result.
Thank you very much for being part of this one.
Thank you.
Before I go, the President Muhammadu Buhari signed CAMA into law on Friday, August 7, 2020. The law replaced the 1990 CAMA, provides that religious bodies and charity organizations in the country will be regulated by the Registrar General of Corporate Affairs Commission (CAC) and a supervising minister. CAMA also provides that if there is any misconduct or mismanagement of any association, or if the affairs of an association are being run fraudulently, the Commission may by order suspend the trustees of the association or a religious body and appoint an interim manager or managers to coordinate its affairs. We have looked at the provisions of this law. We've examined some pitfalls there. Part of the thing that we agreed on this platform today was that it is desirable if we can have a charity organization that is specialized in the activities of these kinds of organizations to look into their affairs and advise accordingly and also regulate them. It has also been agreed on this table as well that churches, and I love that religious bodies should be models of transparency, equity, probity, good governance for the public if they are going to speak truth to their callings. We also agreed that there could be rooms for amendment, and those who are aggrieved should go through the process of amendment rather than just talking about it in the public. But I just wish that we'll have a time where this nation will come together and agree on issues and deal with it in a civil manner. Dr. Olu Ojedokun, barrister and solicitor, Faculty of Law, Leeds City University. Thank you for speaking with us today.
It's been my pleasure.
Well, that's it on Insight for this week. I must thank you for being part of this edition of Insight on Splash 105.5 FM. For more inquiries, you can reach me on Twitter at Oluwaseun Akinola, at Oluwaseun Akinola, 0811 2494 231, 0811 2494 231 for SMS only. I'm Oluwaseun Akinola. Do have a wonderful Sunday.